Good afternoon, everyone. It's great to see you here today at the State House. My name is Diana DiZoglio. I'm your state auditor. And today my office released an audit of settlement agreements, including the use of non-disclosure, non-disparagement, and other confidentiality clauses across 21 state agencies. This audit actually brings our office up to date with respect to the mandate, the legal mandate to audit all of these state agencies at least once every 3 years. So I first and foremost want to thank the staff at the Office of State Auditor for their tremendous work on making sure that we were able to get this work done and been very diligent in making the vision of meeting that mandate a reality in our office. This particular audit examined state universities, colleges, independent and quasi-state agencies, and constitutional offices. And this audit marks the second major report released by the Office of State Auditor as part of a wide-ranging and comprehensive review of how state agencies handle settlement agreements with employees. This second audit covers the time period beginning in 2019 through the end of 2024. And during that time period, our audit found that the 21 agencies reviewed entered into at least 263 agreements totaling roughly $6.8 million in taxpayer funds. Perhaps the most concerning out of these agreements was a $1.375 million taxpayer-funded settlement executed by Massport in 2022. That settlement utilized confidentiality and non-disparagement language, concealing a host of allegations. And these allegations include gender-based discrimination, disability-based discrimination, unequal pay, disparate treatment, and publishing false and damaging statements. The audit found widespread inconsistencies with how agencies manage these settlements. 19 of the 21 agencies didn't have written policies explaining how settlement agreements should be approved, documented, retained, or tracked. And without clear documented policies, as our prior audit also highlighted, agencies can't ensure that settlements are handled fairly, legally, or consistently across state government. This lack of structure also makes it difficult for the public to understand how their tax dollars are spent while increasing the risk of accounting errors, because the Office of Comptroller may not be able to properly review settlement payments. Moreover, the audit found that 20 out of the 21 agencies had no written policies governing when or how to use non-disclosure agreements or non-disparagement agreements. Without clear guidance, there is a risk that confidentiality clauses may hide harassment, discrimination, or other unethical or unlawful conduct, potentially allowing bad behavior by perpetrators to persist while forcing potential victims into silence. In addition, the absence of documented policies creates the risk that these confidentiality clauses may conceal patterns of poor management or misconduct within state agencies, exposing employees to continued abuse and increasing the likelihood that taxpayers will bear the cost of ongoing settlements or litigation. The audit also found that 3 agencies failed to provide in a timely manner all requested settlement agreements to the Office of State Auditor, despite the office's clear legal authority to receive and review these records. Because key records were missing or received just last week, as the report was being finalized, our auditors could not review these settlement agreements to determine their compliance with policies and regulations. 3 agencies also omitted 12 settlement agreements from the list they submitted, totaling more than $492,000 in taxpayer dollars. Furthermore, our review of Massport raises concerns that there may be additional settlements that have not been disclosed or found through our review. The audit also found that 7 agencies failed to report 13 settlement agreements to the Office of Comptroller as required by state regulation. Failing to report settlements to the Office of Comptroller is not only a violation of state regulation, but it can also lead to improper accounting, incorrect tax reporting, and a public perception that agencies may be purposefully seeking to conceal these records to prevent scrutiny. Additionally, several agencies could not provide appropriate documentation connected to 37 settlement agreements that included confidentiality clauses. Failure to create or retain complaint records or documentation that justifies the use of confidentiality clauses raises concerns that confidentiality clauses could be used to cover up allegations of misconduct. The rationale regarding the utilization of such language should be clearly documented and maintained. Taxpayer-funded non-disclosure agreements continue to be used across state agencies and can provide cover for alleged unlawful and unethical behavior. While this administration's new policies, released on the heels of our prior audit of these issues, have been somewhat of a helpful first step, it is unacceptable that the legislature and governor have still not worked to pass a law banning the abuse of taxpayer-funded non-disclosure agreements. As we can see, these agreements are still able to be used across state government and are still being used. Agencies can say that they're following policies, but the reality is that there is no law with any consequences for violating these policies. In fact, some of the comments to our auditors from the agencies in this report were about how they're planning to continue to use confidentiality clauses because there's nothing in the law to stop them from doing so. With respect to Massport and other quasi-public agencies, they're not even actually required to follow the state regulations that the executive branch agencies have to follow. The mandate that they at least report the settlements that they enter into to the comptroller's office. The quasis don't have to follow that regulation. So as I've been saying for years, to those of you who have been around this building for years, it is beyond past time that we stop allowing taxpayer dollars to be abused by concealing allegations of unlawful, unethical behavior across our state government. Additionally, the Attorney General and Massport improperly shared sensitive information about the audit with their employees and retirees who are not involved in the audit. This jeopardized the integrity of the audit process with respect to generally accepted government auditing standards, which our office is required to follow under law, and which dictates that we are not to share the details of ongoing audits so as to maintain the integrity of the audit process. During the audit process, auditors requested access to personnel records, which they are legally authorized to review, and which I will add, we have reviewed throughout history, since the inception of the auditor's office without restriction. The action taken by both agencies obstructed our access to records as authorized by Chapter 11, Section 12 of the Massachusetts General Laws. Contrary to the clear language of the law, these agencies sent letters informing employees and retirees that these specific records were being reviewed and invited employees to object to the audit and to quash our office's legal authority to review these records for this audit. By doing so, they interfered with lawful oversight while delaying, and in Massport's case, blocking, our statutorily authorized access to these records required to conduct our audit. That's why we're planning to sue Massport to get access to these records that were improperly kept from our auditors. And since the Attorney General's office claimed the same exemption for themselves and also previously assisted the governor in the first audit that we did of settlement agreements to also try and block our access to these documents and records, the AG is conflicted out and cannot represent our office in this lawsuit. Our office provides oversight for over 200 state entities. We regularly request and review personnel data and other personally identifiable information, including personal health information. Let me give you some of the countless examples of the records that our office has reviewed in recent years. Massachusetts Convention Center Authority. We all know about the allegations going on with the Massachusetts Convention Center Authority, and our office conducted a review in 2023. It was issued in 2024, and our office reviewed for that audit personnel files and personnel records in connection with employee complaints and employee settlement agreements. We accessed those records in order to conduct that review, and that was released in 2024. Prior to my taking office, and under the prior administration, under the prior auditor, the Hampden County District Attorney's Office, with an audit that began in 2022, again before I took office, we selected a random sample of 10 employees from their personnel files and determined whether the information in the personnel files matched the data in the Massachusetts Management Accounting and Reporting System, also known as MMARS. We also selected a judgmental sample of 10 employees from MMARS and traced that information to personnel files to conduct that audit. The Division of Capital Asset Management and Maintenance, 2021 that audit began, again under my predecessor. Our office reviewed employee personnel files to determine whether employees had cybersecurity awareness training certificates on file. Again, under my predecessor in 2019, the Department of Industrial Accidents, we examined that employees' personnel files that they had been approved for, that employees had been approved for and received a flex time schedule. Also, under my predecessor, in 2019, the Greater Springfield Senior Services, Inc., we randomly selected 10 employees from the list obtained, as well as their personnel files, and documented their dates of hire. We tested the entire population of 15 Protective Services Unit employees hired during the audit period by reviewing the 15 employee personnel files. Worcester County Sheriff's Office, 2018. Again, before I took office, we selected a non-statistical judgmental sample of 33 time and attendance records and determined whether information in that system matched information in hard copy employee personnel files. And lastly, my personal favorites, considering the time period that we are living in right now, State Auditor Joe DiNucci conducted an audit of the legislature. That audit was released in 1992, on January 15th, 1992. And that audit was ironically conducted at that time period at the request of the then Attorney General to examine allegations of fraud where a court officer was receiving two forms of payments, one which was deemed to be inappropriate. So former Auditor Joe DiNucci took that audit, audited the House of Representatives, and the entire audit was focused on reviewing personnel records. Specifically, this office reviewed documentation maintained by these agencies with respect to time and attendance, salary payments, accident reports, appeal reports, and related files. Had our office not been able to access personnel records in connection with our 1992 audit of the legislature, our attempt to provide oversight would have been rendered meaningless. And I have to say that it certainly seems as if that is the intent right now, to render the oversight that this office provides essentially meaningless when it doesn't suit the agenda of the powers that be, which is unacceptable. Our review of personnel files that we were actually allowed to review at Massport uncovered an additional 7 settlement agreements that Massport itself actually failed to report to our office. We only found these additional settlement agreements because we examined these particular personnel files and because these employees chose to allow this review of these records. But had we not sought to review Massport's claims that they had already provided us with all the information that we requested, essentially they were asking us to trust without verifying. Had we not looked at these personnel records, these would have gone under the radar and undetected, lowering the overall amount of expenditures Massport would have appeared to have made with respect to settlement agreements, including those containing non-disclosure language and confidentiality clauses. And it's important to say that this was just a sample size, and that if our office had more time and more resources and was able to really dig through these files without the 3-year mandate looming over the office's head, we could have continued this on. And we're pretty confident that we would have found a lot more of these agreements based on what we were able to find, which is that smaller sample size over at Massport. This underscores why these reports are called audits, because we actually go in and need to verify what agencies are claiming and not just rely on their testimonials as evidence. We need concrete evidence. The auditors go in and they audit. They don't just interview. That Massport withheld 10 personnel records is concerning. The recently publicized circumstances involving a now former state employee with a criminal history who has been arrested and faces serious charges related to criminal activities allegedly conducted on and at the job in the governor's Western Mass office underscores the need for access to personnel records to ensure proper oversight and compliance with all applicable laws, regulations, policies, and best practices. We've all seen that settlements with public employees can come in many different forms, and we, the taxpayers, wouldn't know that $30,000, roughly $30,000 of our hard-earned tax dollars went out to someone who was fired from their position after arrested on charges of cocaine trafficking and unlawful possession of a firearm if you in the media didn't report that. But these types of inconsistencies and mistakes where agencies or this administration essentially know that something has been done wrong, these are exactly the types of things that our office is able to audit and to dig deeper on to help shine a light on how and why issues like this happen. And I can't tell you how often I get calls from people across our communities or from people in the media asking our office to examine things and to dig deeper into issues that have been raised to you and ask us to get access to records that you're being blocked from, because our office has the statutory authority to dig a little bit deeper than maybe the general public is able to do with their limited access to these documents. So essentially our audits exist to help. We're here to look at these issues, to provide guidance, and to make sure that these types of problematic issues don't continue on and on without addressing the underlying causes for why they were able to occur in the first place. And we hear all too often people saying, well, they're just slapping a Band-Aid on the issue, and what they mean by that is when there's a problem that's identified, it seems like people can get a little bit anxious and want to deal with those issues really quickly and make the problem go away. And we all, as real human beings here, we understand that desire for people to want to just move forward through something. I think it's a natural tendency that people have, whether they're working in government or outside of government, to try to resolve an issue quickly and move forward. But our office exists to go in and do those deeper dives needed to ensure that those issues that everyone wants to move on quickly from, that those issues still get an examination, so that we don't just continue to see repeat behavior after repeat behavior, and we can actually examine the root of the problem that was never identified potentially, so that's worked on and addressed fully. So the symptom might be resolved through a firing, a lawsuit to recover funds, and other actions taken after the fact, but our office goes in to work on addressing the underlying root cause, and then we make recommendations to protect agencies moving forward so that they are hopefully better positioned to be able to prevent these types of issues from occurring in the future. We provide a service in this way. However, the Governor, Attorney General, and Massport have all very recently misinterpreted the law allowing our office to do this work. And I believe that they are setting a very dangerous precedent if allowed to continue in this manner, going unchallenged on this. Under their preferred interpretation of the law, bad actors across our state government would be entitled to block statutorily authorized reviews of their personnel records by state oversight entities anytime they feared such a review might reveal misconduct. And it's absolutely critical for oversight and the public's faith in government that potential bad actors not be provided the opportunity to prevent appropriate accountability through false application of law at the expense of you, the taxpayers. Governor Healy, even though she is now citing this as something she believes in, the ability to quash and object to these audit reviews of these personnel records, never raised this issue previously when she was the Attorney General. As I went through the list of audits that our office had conducted, most of those, as you probably recognize by me repeatedly saying it to you, were conducted under my predecessor. They weren't even conducted under my time in this office. So my predecessor, former Auditor Suzanne Bump, was able to access personnel records, while the current governor, who now has a problem with our accessing these records, was the Attorney General at that time. But now we're hearing that suddenly this is some big issue, and that employees across the Commonwealth should be able to block the auditor's access to records that we need to be able to conduct our office's reviews under law. You can't have it both ways, friends. So, if I can ever get a return phone call from our governor or some of the folks who are alleging that these issues exist and that this misapplication of law is actually the way that things should be done, I would like to ask what has changed between all of the years preceding this administration and why suddenly, just now during this time period, our office should now be limited in what we are able to access with regard to personnel records. I just want to add that when we talk about things like personnel records, we're talking, friends, about even getting access to cybersecurity training. We've done audit report after audit report, making sure that agencies are following cybersecurity training. Some institutions have been hacked, and we go in and we said, have you done all of your training? Have you done your ethics training? Have your employees actually completed their ethics training in accordance with the policies, regulations, and laws that are supposed to be followed? Those are the types of records that if this precedent is set and allowed to continue, then our office would no longer be able to review. So this is a threat to our office's ability to conduct its work. And we are going to be, as I said, suing Massport for these records, and we are calling on the Attorney General to allow us to have an attorney of our choosing to represent our office, one that is not conflicted out as our Attorney General is. Thank you.
Audit, you mentioned that some of these agencies were encouraging parties to the NDAs to publish your audit. What was that like? You get angry letters from lawyers, that's in a lawsuit?
Massport wouldn't show us the evidence for the documents that they withheld that said that an employee requested that they not release these documents to us. They just informed us, is my understanding, that they just were not going to release these records, and that employees had essentially made a statement that we were reviewing these records. Again, we can't tell who requested what, whether it was Massport putting pressure on the employees to do so, whether the employees were the ones that called in, how that occurred. What we do know is that it's unlawful, and it's not happening with respect to our office's audits until this administration.
So it's just Massport?
Massport was the entity that we chose to do the random sampling for our data reliability portion of the audit, which goes in, and it's the trust but verified portion of the audit, where they give us a list of their settlement agreements, and we go into the personnel files and say, great, you told us you had this many personnel, this many settlement agreements on file, but we found an extra 7 in addition to what you claimed, and these additional 7, some of them had confidentiality language in them. They had not reported that previously to our office. They say that it was a misunderstanding, that they didn't consider them to be settlements, yet they included the language, and I quote, settlement agreements in some of these settlement agreements. So, you know, without that evidence, one can't say, but what I will say is that the governor is actually the first one to choose to state in one of these audits that their office is not going to release some of these records. And that was actually done according to the governor's office under the advisement of the current Attorney General, and that was in the prior settlement audit. No other state entity, when we've gone in to get cybersecurity documents, when we've looked at health information, our office audits Medicaid. We look for fraud. We look through our Bureau of Special Investigations. We have access to personally identifiable information that would otherwise be redacted from public records so that we can identify fraud. Another example is DCF, Department of Children and Families. We were accessing health data around young children who are in the custody of DCF, and we were able to access that very sensitive information to audit DCF and find out where there were gaps in the system, and to track whether DCF was actually doing its job with respect to giving mental health services to these young children and tracking their mental health records through electronic backpacks, as they're known. So we do this quite often. It's generally speaking just a routine matter of auditing. You've not seen this level of pushback until the governor claimed this last year. And now Massport and the Attorney General's office have also claimed that this exemption exists, and it seems like this is going to become a pattern, which again will disempower the Office of State Auditor and essentially render our office's oversight authority meaningless if we can't get access to records.
Madam Auditor, have you talked to the AG or informed her of your interest in suing Massport?
So we set, and I'll let my general counsel, Michael's here today, speak to the litigation portion. He did send that letter over to the Office of the Attorney General this morning, advising them that we were going to be seeking litigation. They have been well aware of our disagreement with them on this position since the last audit that we conducted, that we let them know that this was a misapplication of law. We disagreed with them then, we disagree with them now, but now that it seems like this is going to be a pattern, we have no other option besides to file suit.
So I know there's been the, let's say, stalemate over your attempt to sue with the audit of the
I
legislature.
find out about that.
I heard a little something somewhere. How hopeful are you that you're going to be able to get outside attorneys and go ahead with this?
You know, I think it's important that people in the general public know about what's happening up here, because if left alone on this, I wouldn't be very hopeful. I essentially am holding this press conference today to get the word out that this is an effort that is happening up on Beacon Hill, and that this effort goes beyond this one audit. This is something that will impact our oversight authority across essentially not necessarily all the audits we do, but many of the audits that we do. That again, look at even the most basic of things like cybersecurity training and whether that's happening or not. And we've never had this issue before. It's important that people know that this is what's happening. And yes, it seems to be a new trend that is developing up here to block our office's access to being able to get the assistance we need from the Attorney General's office. I believe that it's incumbent on the AG's office because she herself claimed this exemption for her office, and she claimed that this is the proper application of law, but her office was actually an office that was under audit for this particular review. That in and of itself is a direct conflict. With the audit of the legislature, the games that we're seeing with that blocking of our office from accessing a court is all sorts of games and allegations about not being able to access documents or questions being answered from our office. I've repeatedly called on the AG to subpoena whatever she needs. I'll happily skip to court and meet her there since she's alleging she hasn't gotten what she needs. We've repeatedly answered over and over again. We've released over 150 pages of the communications between our office and the AG's office about that particular issue that clearly demonstrate, for anyone who's interested in spending your Friday night, getting yourself a glass of wine and reading through and perusing those documents, you will see that our office repeatedly answers the questions, and we are repeatedly asked the same or very similar questions in return with an allegation that we didn't answer questions. I've never seen gaslighting occur at the level that I've seen it during this particular time, people in this building, and that's saying something because there's been a lot of gaslighting throughout the years in this building. But this time period seems to be a time period in which people are feeling up on Beacon Hill. Those in power seem to be feeling a bit emboldened to keep pushing to see how much they can get away with withholding under the law. And it's unacceptable. I just keep calling it out because, Katie, to your point, you know, how confident am I that we're going to actually get our own attorney? My confidence is boosted when people know about what's happening here. Because when people know, I know that they're going to call the Attorney General, they're going to call the governor, they're going to call the powers that be, and they're going to let their voices be heard and say, we want access to these documents. And why are you blocking legal oversight that's existed up until this year, apparently, all of a sudden just now stopped?
Could you or someone from your office speak to the legal or historical precedent for being able to access these records at Massport? And then I'm just curious, why bring the lawsuit now if the governor's office claimed the same exemption previously?
So during the last review, when the governor's office claimed the exemption, what they did was they held the documents until the very end of the audit. And then once our audit was complete and we told them we're getting ready to release this, then what they said is, well, now we'll give you the records. They waited until the very end of the audit, when the audit had been through the complete quality assurance process. It had been going on for well over a year. We had been working to try to get access to the documents. We had asked the AG to represent us on this matter as well during that time period. The Attorney General's office, who claimed to be representing our interests on that matter, we actually found out that they were simultaneously coaching the governor's office to withhold the same records that they were literally at the same time telling us they were working to get from the governor's office, and we were made privy to some of that information. So they've been coaching the governor's office to cite FIPA and to misapply that law, and they had said essentially that they were going to do the same thing when it was their time to be audited on this issue. And the governor's office said that they essentially followed the lead of the attorney general at the time, and they withheld these records. But because they did say that they would make them available at the end of the audit, even though the audit had already been completed and our resources had shifted onto the next audit that we were required under law to conduct, our office didn't see the value in trying to sue for those records. It would be a difficult case to make that the records were provided so late that they did prevent us from doing our audit work at the time. But technically speaking, they could claim that they did eventually, say they were going to release some of the audit or some of the records that they were withholding. So, we decided to proceed and to let people know that that was what occurred, move on. But now, this is something where they did fully withhold the records, and they're still withholding the records, and they're not saying that they'll give them to us later, or that, they're still going to have conversations with us, which is a delay tactic that we often see in some of these agencies. What they're saying is they're not going to release the records, and the Attorney General is saying she agrees with that interpretation of the law, and that they are able to withhold records that they choose to withhold, and they are essentially going up against the precedent set essentially from 1849 that gives us access to all these documents.
In the press release, and like you mentioned, the Attorney General and Passport improperly shared sensitive information about the audit, but the audit spans two Attorney Generals, the current Attorney General and the former who's currently the governor. Can you clarify which Attorney General's office shared this information, or was it both?
The current Attorney General's office shared this information.
And then it also mentions NTA policies. Is there a requirement that agencies have written NTA policies, or is that just a best practice?
So after our last audit on this issue, which was a rather large audit as well, and it identified millions of taxpayer dollars that went on with settlement agreements, including confidentiality clauses, non-disparagement agreements, non-disclosure agreements, that were used to conceal allegations of harassment, discrimination, and misconduct in the workplace. Governor Healy did, on the heels of that audit report, right as we were releasing it, some of you may remember this, institute executive agency policies that ban the abuse of these non-disclosure agreements across executive branch agencies. This audit review was of colleges and universities, independent agencies like constitutional offices, and of quasi-public agencies, which do not fall under those executive branch policies, highlighting the need for a law to be passed that prevents the abuse of these agreements across state government and not just in executive branch agencies. What we are calling for is for this law to be passed because the policies are not cutting it.
And what are your plans for re-election?
I'm not going to speak about campaign issues in my office, but feel free to call me if you'd like to.
Just to spell it out a little bit, do you feel that your ballot question, how loud you've been about wanting to audit the legislature, is now impacting your ability to do your job in other spots, in these other audits?
I don't know that it's the audit of the legislature that's impacting this particular issue. I think that it is the willingness of those with the power to do something up here to engage in misapplication of the law when it's convenient and when it suits them. And I think that's the issue. I think that, with respect to the legislature, it is helpful to legislative leaders and the Attorney General, who saw a whopping increase in the millions to her budget. While even our local DAs were only seeing roughly 3%, the Attorney General got, I think it was between 10 and 12%, millions of dollars more than those local DAs who take most of the cases in our courts, I would say, we're actually getting. It was helpful to them during that time period, and it's still helpful to them to block the audit. We can't get access to even financial receipts. They will tell you that there is some violation of separation of powers. Good luck to everybody, saying that after this next November, where, it's potentially going to be another law change that gives everybody, access to these things. I would say that blocking access to financial receipts, everybody that I've spoken to at least understands that has nothing to do with the legislative process. And state contracts, those are administrative records, those are not legislative records. So it's convenient and it's helpful to them to block access, those particular leaders, and it's convenient for the AG to block access because she benefits in her budget. So I do believe that there is collusion and conspiring going on behind the scenes in that regard, and that it needs to stop.
Madam Mayor, you used the phrase gaslighting a couple of minutes ago. Could you more clearly spell out where you believe that's happening and by whom?
Yeah, so, when I say gaslighting, essentially what I mean is you will say something and do something, and someone will essentially look back at you and say, you didn't say and do that. So what I'm referring to with the gaslighting is we will answer questions over and over and over again. I've actually invited the Attorney General we have some folks from GBH here today, onto GBH Radio to have a public conversation with me about this. And let's have a conversation where people can see what questions they allegedly need answers to, and then I can stand there and in front of everybody answer whatever questions are needed, but the Attorney General refuses to meet me for that public conversation, and instead continues just to allege that she can't enforce the law as the top law enforcement officer in this state. And, when I say gaslighting, it's essentially turning the tables on someone and saying it's their fault that something is happening. If you ever saw the movie Gaslight, is that the name of the movie? Yes, I get thumbs up from the back there, thank you. But our office has done everything we can. We are practically begging for the Attorney General to let us get an attorney to go to court. I would add, she can sue anytime she wants to. Gaslighting the general public would be her telling the general public that she can't sue, that she can't do her job because somebody else is getting in the way of that. We see that the Attorney General, when she wants to, sues whoever she wants to. It's a decision that she and only she can make. So when she says she's not going to allow my office to get our own attorney for our lawsuit, the question back to her should be, well, why aren't you filing your own lawsuit to make sure that this audit is getting done, for example? Why aren't you filing your own lawsuit? Why does the auditor even need to ask you to represent her or give her her own attorney? You're the top law enforcement officer in the state. You're the person who sues. You sue the president, you sue different bad actors across our state government. She just doesn't want to sue is the answer. And she doesn't want to have to say that she doesn't want to sue because 72% of the general public went out and voted for this, and they want answers. And it's more convenient for her to say, well, she can't do her job because I'm not giving her some information. Well, that would make me pretty powerful. If I can just stop the Attorney General from filing lawsuits. But friends, I don't have that kind of power. You know it, I know it, I think the general public knows it, so I'm just calling out the gaslighting for what it is.
Madam Auditor, just for clarification, is it a matter of the Attorney General's office asking you questions that you don't feel you should have to answer, or is it a matter of you don't, like they haven't actually sent you questions, but they keep repeating the same questions?
They keep repeating the same questions, and then from time to time they'll creatively come up with like a new issue of concern as a delay tactic, essentially, so this goes on forever. But you're not going to tell me or anybody else in this Commonwealth that it's taking over a year or two to ask the questions that you need answered and that you somehow are prevented from doing your job when you're the Attorney General of this Commonwealth. What's one example I can think of to give you? So one of the questions that they're asking us right now, that is essentially a trick question. It's essentially what could your office potentially, audit, what will your office potentially audit in the future? I don't know if I'm going to be the auditor in any particular given year in the future. Somebody else could be holding this office. And I don't have a crystal ball for the Attorney General to say that this incident of fraud is going to occur in the year 2030, and I'm going to need to conduct an audit of that fraud at that time. With the last audit that was conducted of issues within the legislature concerning personnel matters, that was an allegation of fraud that was made, and it was deemed that fraud was actually occurring. I'm sure former auditor Joe DiNucci didn't know 4 years before that, that was actually going to be raised to his office by the Attorney General at that time. You couldn't predict years from now somebody's going to be accused of fraud and then list that out in advance of being able to conduct the audit. So what the Attorney General is asking me to do is essentially to psychically predict what is going to happen in the future that we might need to audit. And what I am telling the Attorney General to do is to stay focused on the discrete issues at hand, because we are not suing about a future audit. We're not bringing to the court a future issue or a hypothetical issue. We are bringing to the court a legitimate disagreement about the interpretation of law with respect to our access to certain records. And I have repeatedly, and I'll say it again, as though all of you haven't heard this already, I've only requested access to financial documents such as receipts and state contracts. That is it. That's all we've asked for. What the Attorney General is trying to do is make it into this grandiose conversation about the potential that at some later date in the future, some person in the auditor's office could try to get access to documents that she doesn't think they should be able to access. Okay, we're not doing that. So save that conversation for if that ever actually happens, and allow us to go to court for what we are trying to audit in real life here, not in some hypothetical, made-up set of circumstances that really is just meant just to obstruct our office's access to the records we're seeking now, and try to make sure that the law is not followed. Anything else, folks?